A single misplaced comma in a legal contract cost a company over $3.2 million. That's not a typo. That's the actual figure. This isn't some abstract legal theory. It's a real U.S. federal court case that sent shockwaves through the legal and business worlds. You're about to discover how one tiny punctuation mark, often overlooked, transformed into a multi-million-dollar liability. This story isn't just about a typo. It's a stark warning about the precision required in every legal document you sign, whether it's for a job, a house, or a business deal. The details of this case reveal a critical lesson about why every word and every comma matters, and how misunderstanding them can devastate your finances. The core of this incredible case began with a simple agreement between a dairy and its truck drivers, but the seemingly straightforward language held a hidden bombshell. Our story takes us to Oakhurst Dairy in Maine, a company that processes and delivers milk products. Like many businesses, Oakhurst had a contract with its truck drivers regarding their compensation and how certain activities would be paid. The dispute arose from a specific clause outlining when drivers would not be paid overtime. The contract listed several activities that were exempt from overtime pay, including the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of 1. Agricultural produce, 2. Meat and fish products, and 3. Perishable foods. This sentence looks fairly standard, right? But buried within this seemingly innocuous list was the seed of a multi-million-dollar lawsuit. The placement of a single comma, or rather the lack of one, would become the central point of contention, and it wasn't immediately obvious to either party that this seemingly minor detail would spiral into a massive legal battle. For years, Oakhurst Dairy interpreted this clause to mean that their truck drivers were not eligible for overtime pay for any of the listed activities, including the distribution of perishable foods. The company believed that because distribution was part of the exempt list, drivers who primarily distributed goods were not due overtime. The drivers, however, saw things differently. They argued that the contract's wording was ambiguous and, crucially, that their primary job function, distributing the products, should actually qualify for overtime pay under Maine State Law. This wasn't just a disagreement about a few hours of pay. It was about years of back pay for potentially dozens of drivers, amounting to a significant financial burden for the dairy. The drivers felt they were being unfairly denied wages they were legally entitled to, setting the stage for a dramatic showdown that would hinge on a single piece of punctuation. To understand the heart of the dispute, we need to look at Maine's overtime laws. Maine Revised Statutes Title 26, Section 664, subsection 3, states that certain employees are exempt from overtime pay. Specifically, it exempts the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of 1. Agricultural produce, 2. Meat and fish products, and 3. Perishable foods. Notice anything familiar? The contract language directly mirrored the state law. However, here's where the legal interpretation got tricky. The law itself was designed to exempt employees involved in the preparation of these goods for distribution, not necessarily the distribution itself. The key question became, did the contract's phrasing, by mimicking the law, also carry the same legal interpretation, or did its specific punctuation create a different meaning? This distinction would prove incredibly costly, highlighting the critical importance of legislative intent and precise drafting. The entire case boiled down to the lack of a serial comma, also known as an Oxford comma, before the final item in a list. Let's re-examine the clause. Packing for shipment or distribution of 1. Agricultural produce. If there had been a comma after shipment, packing for shipment, or distribution of, it would clearly separate packing for shipment as one exempt activity and distribution of as a separate, distinct exempt activity. Without that comma, the phrase packing for shipment or distribution could be read as a single, combined activity, the act of packing for shipment or packing for distribution. This subtle difference in interpretation meant that distribution on its own was not necessarily an exempt activity, only packing for shipment or distribution. The legal argument became, does distribution stand alone as an exempt activity, or is it merely part of the larger packing for shipment or distribution activity? This seemingly minor grammatical point had enormous financial implications. The truck drivers argued that because Maine law intends to exempt activities related to the preparation of goods, not their final delivery, the contract should be read in their favor. They contended that their job was primarily distribution, a separate activity from packing for shipment. If distribution was not explicitly and unambiguously listed as an exempt activity on its own, then under Maine law, they were entitled to overtime. This argument leveraged the legal principle that ambiguous contract language, especially in employment contracts, is often interpreted in favor of the employee. They pointed to the missing comma as evidence of this ambiguity. They highlighted that without a comma after shipment, the phrase packing for shipment or distribution acts as a single unit, meaning only the act of packing for either purpose is exempt, not the act of distribution itself. Their case hinged on proving this subtle grammatical distinction was not just a preference, but a binding legal interpretation. Oakhurst Dairy naturally defended its interpretation. They argued that the phrasing in their contract was taken directly from the Maine statute, and therefore, it should be interpreted in the same way the statute was intended. They contended that the plain meaning of the text, even without the serial comma, clearly conveyed that distribution was an exempt activity. They also argued that the intent of the contract and the state law it mirrored was to exclude these types of workers from overtime. Furthermore, they had been operating under this interpretation for years without issue, suggesting a common understanding. The dairy maintained that the driver's interpretation was a strained reading designed to extract back pay, and that a single missing comma should not overturn years of established practice and the clear intent of the agreement. They were prepared to fight this all the way, believing their reading was both reasonable and legally sound, but they significantly underestimated the power of punctuation in court. The case eventually reached the First Circuit Court of Appeals in Boston. The court, in a unanimous decision, sided with the truck drivers. The judges focused on the principle that if a contract's language is ambiguous, it must be interpreted against the party that drafted it. In this case, Oakhurst Dairy. Judge David Barron, writing for the court, famously stated, "For want of a comma, we have this case." He explained that because the clause could reasonably be read in two different ways, either packing for shipment and distribution's separate exemptions, or packing for shipment or distribution as a single combined exemption. The ambiguity had to be resolved in favor of the employees. This meant that distribution was not explicitly exempted on its own, and therefore, the drivers were entitled to overtime pay. This ruling solidified the critical importance of precise language and punctuation in contracts, especially when it comes to employee rights. The court's decision meant Oakhurst Dairy was liable for years of unpaid overtime wages to its truck drivers. The total payout, including back pay, interest, and legal fees, amounted to approximately $3.2 million. This staggering figure serves as a powerful reminder of how a seemingly minor grammatical error can lead to monumental financial consequences. The case O'Connor v. Oakhurst Dairy became an instant classic in contract law, illustrating the severe penalties for ambiguous drafting. It underscores that in legal contexts, there's no room for assumptions or implied meanings. Everything must be explicitly and unambiguously stated. This wasn't just a win for the drivers. It was a victory for clarity and precision in legal drafting, forever etching the million-dollar comma into the annals of U.S. legal history. The dairy undoubtedly learned a very expensive lesson. But what can you take away from this? The Oakhurst Dairy case highlights a common mistake, assuming clarity where ambiguity exists. Many people rush through contracts, focusing only on the big numbers or key terms, ignoring the fine print or the precise phrasing. Another frequent error is copying and pasting legal language without fully understanding its implications or how it might be interpreted in a different context. This is exactly what Oakhurst Dairy did by mirroring the state statute without considering the missing comma's impact. Moreover, a critical mistake is not having legal counsel review important agreements. Even a single hour with an attorney could have saved Oakhurst Dairy millions. Finally, people often fail to consider worst-case scenarios when drafting or signing. What if the other party interprets this differently? This foresight is crucial for protecting your interests, and overlooking it can lead to devastating legal battles and financial losses. So what steps can you take to avoid falling into this same trap? First, always read every single word of any contract you sign, no matter how small or insignificant it seems. Pay particular attention to lists, exemptions, and definitions. Second, question anything that seems even slightly ambiguous. If you have to pause and reread a sentence to understand its meaning, it's likely ambiguous. Ask for clarification and insist on clear language. Third, if a contract involves significant money, property, or your employment, invest in legal review. A few $100s for an attorney to review a document can save you millions, as Oakhurst Dairy learned the hard way. Fourth, when drafting contracts, prioritize clarity above all else. Use serial commas consistently, define terms explicitly, and avoid overly complex sentence structures. Finally, imagine yourself explaining the contract to someone unfamiliar with it. If you stumble, the language needs work. These concrete actions can prevent your own million-dollar comma mistake. But what if you're already in a dispute? Here's a crucial legal principle that often comes into play: the rule of contra profrontum. This Latin phrase means against the offeror. In simpler terms, if a contract contains ambiguous language, and there are two or more reasonable interpretations, the court will typically interpret that ambiguity against the party who drafted the contract. This rule is particularly prevalent in employment contracts and insurance policies, where one party often has significantly more bargaining power. It's designed to protect the weaker party from cleverly worded clauses that could disadvantage them. For Oakhurst Dairy, they were the drafters and the truck drivers were the employees. This rule was a major factor in the court siding with the drivers. Understanding this rule means that if you're the one drafting a contract, the burden of clarity is squarely on your shoulders. Fail to be clear, and the courts will likely interpret any vagueness in favor of the other side. This is a critical insight many overlook. The Oakhurst Dairy case is a powerful reminder that in contract law, every word and every punctuation mark carries immense weight. The $3.2 million comma should serve as a permanent lesson in precision and clarity. Your financial well-being, your job, and your business could all hinge on a single piece of punctuation. If you're wondering what happens when a contract is signed under duress or through fraud, watch our video on that topic next. It delves into how courts handle agreements that aren't truly voluntary. And if you found this deep dive into legal precision helpful, consider subscribing. We simplify complex U.S. legal cases, giving you the knowledge to navigate your own world with greater confidence. Thanks for watching.